I just think that these applications have gone through a tremendous amount of scrutiny, and they are being denied in some instances, but you can't put all one blanket over this whole thing, because there are certain sites that will have more impacts than others, and I'm all for the balance. That I remember Mr. Greening speaking to it earlier today, that these things all need to be balanced, because some will be very impactful and others may not be, and it's not just on the criteria of you know, the primary use and all those other things, because there are agricultural pieces that can't accommodate all that criteria, but they may be a better location for the temporary event activities. So that's where my struggles are. So
well, it's always the tension between having the case-by-case flexibility and having, you know, reliable standards that can be evenly applied. And I think because, you know, we do have an appeal process, and that can always be utilized. I think, again, the public and applicants are best served by at least starting from a place of clarity, as opposed to starting from a place of ambiguity.
Yeah,
in terms of what.
If I could just interject here, you know, it's not that either department is doing anything wrong, or anybody, applicants or anybody is doing anything wrong at all. It's that we have a situation, for instance, in the Bennett application, where the agricultural department said one thing and planning disagreed and did something else. And all that we're supposed to be doing here is saying, you know,
how did these decisions get made?
So we're not,
all.
and all I'm doing is coming down on the side of, since it's ag land, I'm going with the ag department. Yeah. That's all I'm saying. Yeah. And I'm not trying to say that staff has done anything at all inappropriate or wrong or anything.
No, I understand all
planning,
that.
But I disagree with the fact that we're talking about ag land and ag policy, and I think the ag department, the ag commissioner should have more of a say-so when there is this question about what exactly where these lines are. That's where I am right now. That's what I think should be happening right now. If that should change, that's what the future is about.
So moving right along, the next item on our list is the question of what constitutes grading and what constitutes construction. Because currently the ordinance does not allow any grading or construction that would permanently alter the site. And my interpretation or paraphrasing of how staff is interpreting grading is anything that would require a grading permit, and construction as essentially anything that would increase the footprint of an existing building. Is that an adequate paraphrase, Ms. Null? Okay. So, and Ag Tourism Coalition is suggesting that we should look to Article 8, which has an existing definition of both of those words. Grading is the moving of, I don't have it in front of me, but the grading of soil and materials, and I suppose I need to look it up, the definition of construction. But while I'm looking that up, I'm interested how people feel about, what do you think of when you read the prohibition against grading and construction?
Well, I think of quantities of dirt being moved, like what triggers a grading permit. And I'm not sure what those quantities are. 50 cubic yards is what I think of. I know that a grading permit is only triggered, I mean, you can go out, constantly on our dirt and base roads throughout the county, they have to be graded, smoothed out, but that's not considered a grading per se as far as triggering a grading permit. That's a maintenance type thing. So to widen a driveway on a based road doesn't constitute grading, in my mind, because you're not moving the quantity of dirt to trigger what the permitted definition of grading is.
I agree with what staff has here.
Okay. And just as an FYI, the definition, the Article 8 definition of grading is on page 3 of the ATC attachment. That helps people find what's actually in the general plan now.
Well, there's the question, I've gotten a little confused in thinking about this, because there's the question of how you're going to define grading and how you're going to define construction. And in that sense, the Department of Agriculture has deferred to the Department of Planning. They say right up there in front. So they basically agree with the department, with the planning department. But then the next question is, when you do have changes, that maybe you have some change in the width of the road that doesn't require a grading permit, but does actually cover up more ground, do you count that more ground when you're talking about primary and secondary and all the other kind of things? So this is kind of a two-prong approach here. And again, this is one of those ones where I might very well want to see a policy in the future be more specific, but at this point, I'm probably going to defer again to the departments, and since in this case they agree on what the definition should be, it's hard for me to pick one or the other.
I'm gonna jump right in here because I don't see agreement, I see deference. As I say, Ag saying,
Well,
planning commission gets to determine.
Okay.
We have, this is an easy one. We have a definition of grading and construction right there in our own general plan. We don't need to reinterpret it. We don't need to, get a variety of opinions on it. That's why we have definition of these terms in our general plan, so that everybody is clear about what it means. Grading is grading. And if you're going to grade more than 50 cubic yards, you need a grading permit. If you're going to grade less than 50 cubic yards, you don't need a grading permit. But grading is any activity which involves the physical movement of earth material, including excavating, filling, stockpiling, movement of material, compaction of soil, creation of borrow pits, or combination thereof. And I'm very uncomfortable moving away with established legal definitions of the terms in our general plan, because that's what they're there for. They're there to guide our decisions.
Why doesn't here's a question for staff, why doesn't staff anywhere in ag or planning talk about grading in that way? That's where I was confused in reading about it. If the definition of grading is so clear, because it's in our general plan, why hasn't the department in the past said, okay, well, this is grading since you're widening the road by 4 feet or 10 feet or whatever?
Well, because many times you can widen a road without actually moving any material. In the case of Lem, it was completely level property. The driveway was, it was not, I think there was some base put on it, but the only thing they needed to do was basically mow the edges of their driveway. They did not need to do any earth movement at all.
Right, so they
widen the road.
Except maybe not by our own construction definition.
But what's going to happen is, if it doesn't trigger a grading permit, then what folks will do is they'll come in, find the regulations, they'll go widen all their roads, and then they'll come in for a grading permit. Or then they'll come in for a temporary event permit. That's the option.
Yeah.
Because it's underneath a grading permit.
Yeah.
It just seems like a reasonableness test. If you don't need a grading permit, you just need to widen the road a bit, pull it, blade it. It just seemed reasonable.
If I might add, 50 cubic yards is a very low threshold, and it's not just 50 cubic yards. It's also 2 feet of fill and 3 feet of cut. So, they could be under 50 cubic yards, but if they get more than 2 feet of fill, then
But I would just suggest, though, that we have definitions here, and if we don't want to apply them, then we should change the writing of the ordinance, because right now it's spelled out, any grading.
Right, but we're not talking about we're talking about how it's been interpreted. What's the interpretation?
No, we're not talking about how it's been interpreted, because how it's been interpreted is the controversy here. The question is, how do we think it should be interpreted? How should the existing language be interpreted?
And when we have definitions
I think
in
we're
our
missing
ordinance already, if we don't like having them in there or not allowing them, then we could agree that we need to look at changing the wording.